Hi everyone, I am Catherine Medina, also known as Attorney Catie Online. I am a divorce attorney and owner of Medina Family Law Associates located here in Phoenix, Arizona. Today's video is going to talk about the final trial in the family court system. Now this could be in your divorce case, it could also be in your custody case, and if you end up in a final trial, it's not a failure. A lot of cases end up in final trial for a variety of reasons. But if you end up in a final trial, it's because alternative dispute resolution did not work, or private mediation was not successful, or maybe you and your attorney engaged in settlement discussions back and forth with opposing party and their counsel, and that just did not work. It's also possible that maybe you resolved some pieces of your case, but not all of the pieces of your case, in which case you're going to trial to resolve the remaining portions. Also not uncommon. Now, if you've made it to a final trial, then you've probably been within the court system for several months, perhaps a year or longer. A slew of factors can contribute to how quickly or not your case moves throughout the system, and a lot of them can be out of your control. So if you're at the final court process, or you have a hearing and it's a final evidentiary hearing, significant time has gone on more than likely since you began your case. So that's kind of where we are in the timeline of all of this. And it's going to be different for everyone, but this is really the last stages of a case. So if you need a final trial date or a final evidentiary hearing, you are going to typically meet with the court, and it could just be a status conference or a scheduling conference. In order to set that date, both parties need to certify to the court that they are ready to set for trial. And this is really important because when you certify readiness for trial, you are telling the judge that you guys are ready to proceed for trial, right? So that means that you have engaged in all of the discovery and disclosure, and you have obtained all of the discovery and disclosure that you want in your case. So that if you show up to trial or the day of trial, you're not arguing over an issue and saying, hey, we don't have all of the information that we need, because the court doesn't want to resolve that the day of trial. They want to know before we get there, you're going to be ready to go. That means that you guys don't have anything else that I need to address. You've exchanged the information that's necessary for you to make your case, as well as for me, the judge, to issue an order on these issues. It could be spousal maintenance, child support, assets, things like that. So the most important thing is that you want to go to trial and actually be ready. And a lot of times that means that you need to have all of the information to argue your case. So you want to deal with all of the discovery and disclosure issues before you certify for trial. Because if you show up to trial after you have certified readiness, you may be out of luck. Or you may be looking at having to continue your case to a later date and time. And every judge's calendar is different. And so you may be looking at a short continuance of a month or 2 months or 3 months and so on and so forth. It's going to depend on that judge's calendar. But for a lot of people, they don't want to delay this. By the time you get there, you're usually like, I just can't wait for this to be over. So bear that in mind. You don't want to seek a continuance if you don't have to. So just be ready. Be really ready when you certify for trial. One of the most important things that you're going to do after you've set for trial and you have a date is prepare what is called a pretrial statement. Now, the court typically requires this statement is filed a certain number of days before your hearing. The number of days is going to be included in the minute entry or the scheduling order that was issued by the court that set your final trial date. So once you pick that date, the court is going to issue an order that says your trial date is on this date and time. These are all of what you must submit, your pretrial statement and your exhibits, as well as the deadline to submit them. Your judge can require you to submit this pretrial statement separately or jointly. So when you file them separately, each party files their own statement in separate documents with their own positions. If it is required to be filed jointly, then the parties have to merge all of their positions into one document It's up to the judge on your case whether this is filed separately or jointly. I think most people have a preference to do it separately because then you don't have to coordinate between offices and merge your positions into one document, but that is something to pay attention to in the minute entry setting for trial. So, what is a pretrial statement? A pretrial statement, most simply put, is telling the court what you want. It's setting forth your positions as well as your legal arguments to the court for the day of trial. Now, the judge is meant to look that over before your actual hearing so they know what the parties are arguing about and their basis for those arguments. It's really important that you make any argument, legal argument that you may have in your pretrial statement, because if it's not in your pretrial statement, then it's often something that could be overlooked when you actually go to trial. Or if there's an objection that you want to make later on that was not in your pretrial statement, you may forego that opportunity. So this is really your chance to set forth all of your arguments and your legal positions to the court. So this is going to include things like what you want to do for parenting time, as well as legal decision making. It's going to include a child support worksheet, your proposal for what child support should be, as well as spousal maintenance. If you are dividing assets, you're going to set forth what division of assets you are seeking, if there are values to those assets. For example, a vehicle, and you say that you should be awarded a certain value on a vehicle that the other party is keeping, or vice versa. All of that is going to go in your pretrial statement. And lastly, attorney fees. If you're going to trial, most people are going to make a request for attorney fees because you're already there. You might as well try. And the court will make that determination on their own based on the financial resources and the reasonableness of the parties. But that is all and should all be included in your pretrial statement. Rule 77 of the Arizona Rules of Family Law Procedure governs what a trial looks like. And it's typically meant to follow a certain set of processes. If you are the petitioner on your case because you initiated the case, the petitioner is usually going to present their case first. That means that the petitioner is going to call their first witness and give testimony or any other witness that they may have. So if you have a lawyer, talk with your lawyer about what trial is going to look like and the general process that you can expect, because I find that clients, a lot of the anxiety from trial can come from not understanding what's going to happen. And so when you show up and you don't know who's going to speak first, what they're going to do, that can be really anxiety inducing, understandably so. So the more that you understand, or the more that you know what to expect the day of trial, even just as simple as the process or the format, can really help put you at ease prior to walking into the courtroom, because you're going to be bombarded with the fact that you're in a courtroom setting, which is already intimidating and scary, on top of the fact that you are having to be present and testify oftentimes negatively about the other party in the case, or just be sitting next to them in the room. It's an uncomfortable situation. So the more that you can do to control certain aspects and know what to expect, the better that you will feel. So my takeaway for you is to talk with your attorney about what trial actually looks like. Sometimes there's going to be closing arguments after testimony. It's, going to depend on time and what the judge prefers. The other thing that should happen is a trial preparation meeting with your attorney to go over what to expect at trial. This is your opportunity to ask them questions about what to expect, but really your attorney, when they're preparing for trial, they're going to want to talk to you and get you ready about what questions they're going to ask you. So some attorneys will go so far as to writing out their questions that they're going to ask you on the day of trial, and they may share those with you and say, hey, these are some questions I anticipate asking you. Other attorneys, if they do a really good pretrial statement, or the pretrial statement is an outline of your positions, they may just rely on that pretrial statement and come up with their questions on the spot. I think the more practiced or seasoned a lawyer is, the more they might do that. Everyone has their own preference on whether they do questions write out those questions before trial or not. But you should absolutely be able to meet with your attorney prior to trial to prepare. They can go over the real critical issues, and if you're not sure about what to say on certain things, this is your chance to prepare accordingly and ask your attorney, what should I say on this? What should I not say on this? You're walking through the legal strategy with them to better help you understand the point that you're trying to get across, because ultimately your attorney cannot testify for you, right? This is all going to come from your own mouth. So you want to make sure that you understand the legal strategy and the objectives and the desires that you want to tell the court. Now, the other thing to be mindful of is the amount of time that goes into trial preparation. So we're looking at the time to prepare a pretrial statement. We're also looking at the time to prepare questions, the time that it takes to review your file and get familiar with the disclosures and all of the evidence. Because sometimes we're looking, or our exhibits for trial may be thousands of pages, and we're having to look through that and identify or mark like what specific page we're going to use at trial, because we can't waste time. Time at trial is very precious, and you don't want to waste time flipping through pages or scrolling through 1,000-page document trying to find where you need to get to. So these are all of the little details that lawyers have to be ready for on the day of trial, because, and I tell all clients this, time goes so fast. You are timed at trial, and you typically split that time and share that time with the other parties. So for example, if you have a 3-hour hearing, which is the typical time for a trial in Maricopa County, you are splitting that time with the other side. So you get 90 minutes. So in that 90 minutes, you have to get through all of your issues and all of your evidence. So this is why time is really precious. You don't want to waste it doing simple things or having technical errors. Litigation and trial prep has a general rule of thumb. It's kind of wide, but the general rule of thumb is that you should be preparing 2 to 5 hours for every hour of trial. This may or may not include the time to actually prepare your documents, such as your pretrial statement. I would say most often it does not include the time it takes to prepare your pretrial statement, but they're also going to be organizing exhibits at that point in time. Again, preparing those questions and really just getting themselves familiar with the file, so that day of trial, if a question is asked or something comes up, they know the status of the case and the facts and are familiar with everything that you have told them. So it's a lot of work. It's asking them to remember a lot of things about your case. And of course, they can't remember everything. So that's why prep can be so important, because sometimes there may be little details that aren't really going to be saved anywhere in your file or readily available, so they create their own notes to refer to for trial. But the point is, you want to be ready for anything, really. That trial prep is also going to include reviewing the pretrial statement prepared by the other party. You're not always going to know exactly the positions or the legal arguments that the other party is making until you get that pretrial statement. So once that's filed, your attorney is going to look through that and prepare defenses or objections to what may be in their pretrial statement. So a lot of time can go into that as well, especially the more high conflict or complicated that your case is. These are my overall practical tips for preparing for trial. Of course, if your attorney asks you for information or documents, get those to your attorney on time or before the deadline that they provide you, so that they don't have to worry about gathering information from you last minute. So comply with all of your attorney's requests for paperwork by the imposed deadline that they give you. Talk to your attorney about what positions you want to take for trial, and make sure that you let them know if there are any hard line objectives that you have, or any wishes or evidence or testimony that you want to make sure is addressed at trial. Because even if you don't have all of the time to address everything at trial, it's important that it is at least included in your pretrial statement. So if you are afforded the opportunity to review the pretrial statement before it is filed, make sure that it includes everything that you want to address. Now, the other tip that I have is just preparing mentally for trial. Like I said at the earlier point in this video, talk to your attorney about what to expect for trial so that you can prepare mentally and not be so stressed out, because you, as a party to your case, are going to be testifying in court on the open record, and that can be really scary. But here's the other thing for you to be mindful about, and that is that oftentimes this is the only chance that you will have to tell the court what you want, and it's the only chance that the court is going to hear from you meaningfully. And this is the judge's opportunity to assess your credibility. So if you are not a good witness, if you can't remember details, or you're not really sure what you want to ask for, that can be really damaging, because again, this is oftentimes the one and only time that you're really going to hear from the judge. They basically get to know about you and your marriage or custody case in that small truncated 3-hour trial. So this is their limited view of you. So just bear that in mind, because your credibility and your ability to testify and be a good witness is really important. Lastly, dress and conduct yourself accordingly. I always say, go into court as if you were interviewing for a job, or if you were, going to church. You're going to dress nice. Ask your attorney if they have any preferences on what exactly you should wear. My general rule of thumb is just dress presentable, and be mindful that you are basically under scrutiny the whole time that you're in the courthouse. Even if it's not from the judge, because maybe they're not in the courtroom, their staff is in the courtroom. So if there's any behaviors that are odd or that are off or that are bad, that could get back to the judge on your case. So you're conducting yourself accordingly in this environment. You're being very civil and friendly. And if you simply just need to avoid all contact with the opposing counsel or the other party in your case, then make that known to your lawyer so that they can do their best to try and keep the distance, because physically you may be sitting very close to one another in the actual courtroom. That is my general overview for the trial process. It is a very structural and rule-based process. Talk to your attorney about trial, what to expect, or the advantages or disadvantages of trial. And remember, if you are in trial, it is not always a failure. Many people end up in trial. It is a recourse that is available to you. However, of course, it is our philosophy at Medina Family Law Associates to resolve as much as you can outside of the court system. That being said, it may not always be possible, and there are a variety of factors that may address that. Some of them are in your control and some of them are not. So I hope this video was helpful. As always, contact my firm if you have a family law case located in Arizona. We accept cases all throughout the state, and I hope to see you in the next video.